Welcome back. You're still watching Politics Tonight, digging beyond the headlines. And now to our interview with the guest of the day. I am joined by a lawyer, public policy and social affairs analyst, Liborous Oshoma, for discussion on the 2023 Presidential Election Tribunal and the clamor for transparency. Thank you very much for joining us this evening. All right, so the nitty-gritty of cases at the presidential election petitions is in full force. As a lawyer, how will you describe the proceedings so far?
It's expected because the election was keenly contested, and one would expect that tempers will be up at the tribunal, and all of that has been happening. So it is expected. But so far, the judges have been on top of their game, and so the case management have been awesome. And I like the fact that even after the pre-trial, time has been allotted for each parties to prove their cases. If that wasn't done, and then probably the tribunal would have been out of time within which to hear the matter. So far, it's been so good, apart from the sentiment expressed by quite a number of persons. You've heard a lot of sentiment on what people think judges should do or what their opinion of justice is. But like we say, law is not about sentiment, it's about facts and law. And so that's why you hire competent lawyers to do justice to the matter at the tribunal. So people certainly will express their opinions on how they feel or what they think, but the procedure so far has been one that one would say has been commendable.
All right. So in 6 days, it will be the inauguration of the president-elect. Do you think this should have any bearing on proceedings at the tribunal?
Not at all. Not at all. I've listened to quite a number of persons saying, the president-elect should not be sworn in until after the disposition of the matter at the tribunal. But unfortunately, that is not our jurisprudential practice. That's not our practice. That's alien to us. We are not the type that take matters outside or that dispose of matters before swearing in. We've seen cases where even governors that have been sworn in have been ousted from office. And so this is not the first time we're having such matters. Right from the return to democracy in 1999, we've seen cases where election petitions handled, way after swearing in. It was even what advised the amendment to the Electoral Act and amendment to the Constitution to reduce the time for litigation at the election petition and also to reduce the time for pre-election matters. If you remember the case of Peter Obi and Ngige, it took almost 3 years into the administration of Ngige before judgment was eventually delivered. After that case, the legislatures in their wisdom decided that they would no longer allow election petitions to drag on ad infinitum. And so the number of days were reduced to 180 days. So it is not part of our jurisprudence that election petitions should be disposed of before swearing in. So this is not new. We've also seen where governors have taken oath of office and the courts ousted them from office and then they relinquished the power. We've also seen situations where, although pre-election matters, a day to swearing in, courts decides otherwise. So this is not new. Like that's why I said law is dealt with, with facts and law and not sentiment or whatever anybody thinks. So I do not think, to answer your question directly, I do not think that it will affect the outcome of the Election Petition Tribunal. Anybody that can influence the Election Petition Tribunal, before swearing in can also influence. Anybody that can influence it after swearing in can also influence it before swearing in.
All right, so amidst all of the issues that have been raised, one critical one is the issue of live transmission of proceedings, which the court has ruled against. How will you react to that?
Yeah, it is. I expected that decision, and it is because it is not part of our practice direction. Like I said, it's all about sentiment. A lot of people did not think through those requests before making such requests. I have been part of such election petition matters, and I know in some cases what it takes to bring witnesses to court. Why do we, despite the provisions of the Evidence Act, that a deponent, for example, if you're deposing to an affidavit, you must state your name, address, and source of information. But for election petition matters, there is a caveat, there is a proviso to that rule, that deponents can use initials to hide the identity of witnesses. So a situation where the witnesses that you are hiding their identity through deposition, you now say that you should show those witnesses live on national television. Do you think that those witnesses, in some cases, because of the sentiment involved, you think that people would want to come testify because you have a lot of sentiment, you have a lot of issues? And so in some cases, you might not even see witnesses because nobody wants to put their face on camera to testify in such, cases where a lot of sentiment involved. Some persons can even take it upon themselves to go attack those witnesses. So the first thing is we need to shield witnesses that would, come forward to testify in such tribunal. And then also, we know how lawyers behave in Nigeria. In most cases, we see situations where, a lot of people want to play to the gallery. We've seen it with the National Assembly anyway. On Sunday, on Wednesday, when National Assembly proceedings are transmitted live, you see almost senators and House members would be at their best that day. A lot of them playing to the gallery, frivolous motions are moved just to show to the public that they are working. That would also be the case at the tribunal, because law will take the back seat, where a lot of lawyers will now want to play to the gallery. The tendency to play to the gallery will be very high, and to appeal to sentiment rather than the law. And then, like I said, the judges will not be dealing with sentiment. And then also, lastly, there's a heavy burden on the courts, especially when proceedings are transmitted live. It creates a lot of distraction, for the court, because our court are still largely conservative. Even what they do mostly is to transmit judgments live, but not proceedings. I can take your mind to Ekweremadu's case. Ekweremadu's case that the people saw the transmission of the judgment, but they didn't see, what had transpired during the hearing, witnesses and cross-examination and the rest. Those were not transmitted. So if you're asking for transmission of the judgment, live transmission of the judgment, that should be okay. But to now ask that the entire proceedings be transmitted live, for me, I do not think that we should reduce our judicial practice and legal election petition matters to such alawada, where people now come, to have at-home video rather than do serious business of the law. And another bad precedent that you would be setting, mind you, is a court of appeal. The moment a decision of that nature is given, it's a precedent that lower courts, will likely follow. If a Liborous Oshoma has a land matter or a criminal matter at the Lagos High Court tomorrow, what stopped me from applying to the court that because I don't have faith in the court, that I should that the proceedings should be transmitted live because I want to satisfy some egos of my clients? So we shouldn't set precedents that we cannot sustain, because this is just one matter out of so many other election petition matters that we have. And if you do not have faith in the judiciary, there's no need going to court. We're not going to get judges from heaven to handle our matters. It is judges from Nigeria. So what enhances transparency in judicial proceedings. It's not whether you transmit or you do not transmit. Anybody that will be compromised will compromise. We should have looked at this long ago. The way judges are appointed to our bench, the way also the remuneration for our judicial officers, and also the composition of the NJC that is saddled with the responsibility of dealing with erring judges. All of these are issues we would have been dealing with. But because we are used to a knee-jerk approach, it comes with banter, with sentiment, and that's why you hear all of this. That's not what will solve or enhance transparency in our judicial process.
All right, so Mr. Liborous, let's stay a little bit on this issue. I mean, the PDP and the Labour Party based their petitions for live transmission on the need for transparency. Meanwhile, some legal practitioners have even said access to the court alone is enough transparency. But you're here. Help us understand, what does it take for proceedings at the tribunal to be transparent?
Look, let me see, like you see that, do you think, let me first and foremost, puncture that argument that it is only when you transmit. You have reporters in court. That's enough transparency to report what transpires in court. Journalists have been accredited to report what transpires in court. Lawyers have access to enter the court, go in and come out. So you see the number and array of senior advocates and the number of junior lawyers in court. You think it's all of them that, would have audience, right of audience in court? No. Worst case in that matter, three lawyers will lead the other part. Sometimes some lawyers don't even have business there. They just go there to sit down and listen to proceedings. You also have the galleries where interested parties come to watch proceedings. If that is not transparency, even if you transmit the proceedings live, some persons will still say it is not transparent enough. Like I said, that is not how you enhance transparency in judicial process. Transparency ought to have started long ago, from the way judges are appointed, from the remuneration of judges, from autonomy for judiciary, down to the NJC that deals with erring judges. All of these are how you deal with transparency in judicial proceedings. And mind you, like we say, when a judge sits on trial, the judge is on trial. You are trying a matter, the entire world, who are also listening. The reporters are reporting what transpired in the court also, and then lawyers in court also are granting interviews of what transpired. Even outside of this tribunal, they still have a right of appeal. All of these are ways of enhancing transparency. All structures have been put in place. There are what we call practice direction, rules also as to how proceedings will be conducted. All of these are issues that will enhance transparency at that level. Every other thing for me is superfluous, and then would just be politicians trying to drag, the judiciary in the mud, or trying to harass and browbeat them to doing their bidding. And unfortunately, that is not how to, enhance transparency in such circumstances.
All right, so the tribunal has ruled in favor of consolidation of Atiku and Obi's petition. What's the implication of this?
I think also it is the best thing to do because of time. Like I said, these matters are time-bound. If you allow all of the vagaries of sentiment to determine what should happen, at the end of the day, the petition will be overtaken by events and will be statute bar. So what this means is that all of these petitions will be taken together. When a matter is consolidated, all of the issues are basically the same. The two parties are contesting the election of the APC. And so the court has said, since what the two parties are claiming is almost the same, let us put all of the cases together. Instead of calling this one, you hear this one separately, and then you now hear this one separately. The court has said, put the two cases together. Now you have two parties in one. And the two suit numbers, all of them will be called. You have the first one will have 6 weeks to deal with their matters. And the defense will have a few days to respond. And what also had made this beautiful is the fact that at the end of the day, all the witnesses that are going to be called will no longer be led in evidence, because that also will waste time. The witnesses will just come, adopt their witness statement on oath. This same witness statement on oath, like I said, contrary to the provisions of the rules, as an exception to the provisions of the rule, parties are allowed to use alphabets instead of names and address. Okay. So in this case, you're already, masking the identity of the witness. So when you mask an identity of a witness and you now say, bring camera to put on that witness face, is that not contradictory? Because if you look at the witness deposition of all the parties also, they all have alphabets. So you don't know which particular person is that witness that is being referred to. That is allowed by the law also to ensure that you hide the identity of the witness. So consolidating does not mean, just that it's press sentiment as if, something big has been done. Consolidation is for time so as to deal with the petition, expeditiously because of the nature of the case and the time that they have to deal with it.
All right, so the tribunal has also given Obi and Atiku 3 weeks to prove their cases. What prompted this and what is the implication for the proceedings?
If we keep talking about time here, if you give them, the petition was filed, sometimes election was conducted in February, petition was filed in March, and you have 180 days, which is 6 months within which to deal with that petition. And if you give 7 weeks to each party, at the end of the day, before one party finishes its case, that petition, the time for the petition would have lapsed. And that will mean the tribunal will be denied of the opportunity to deliver judgment on the matter, because the moment it is 180 days, that petition automatically is dead. There's nothing that can resolve it. So to avoid that, the tribunal had to allot time to each party and ensure, like I said, expert witnesses are allotted 30 minutes for examination in chief because they do not have witness deposition on oath. But for witnesses that have their deposition already on oath and have been filed in court, all they are just coming to do is to adopt the statement. Is this your statement?
All right.
Yes. How do you recognize it? I recognize it because my signature is there. And what do you want the court to do with this? I want the court to take this as my testimony.
Thank you very much, Mr. Liborous.
And that is it.
Thank you very much. Thank you so much. I've been speaking with Liborous Oshoma, a lawyer, public policy and social affairs analyst. And tonight we discussed the 2023 Presidential Election Tribunal and the clamor for transparency. Thank you very much, sir, for coming on the show and for always finding time to help us, explain the position of the law on some of these national issues. Thank you very much for coming. Thank you.
My pleasure always.